Good morning, students. Today we are going to study the liabilities of a company auditor. As auditor is appointed under Companies Act, his liabilities are determined by the Company Act itself. So, therefore, this liability of an company auditor has been divided into two parts. One is civil liability, one is criminal liability. First, study what is civil liability. Civil liability is a liability of an auditor, that is, if a company suffers a loss or damages due to auditor, then it is considered as a civil liability. So, in this case also you have two things. One is liability for negligence, liability for misfeasance. What is liability for negligence? Liability for negligence is that if auditor, without taking a reasonable care and skill in performing his duty, and because of that reason if the company suffers a loss or a damage, then such liability will be called as liability for negligence. That is, auditor has not performed, or auditor carelessness or showed his negligence in performing his duty, in discharging his duty, means such a liability will be considered as a liability for negligence if a company suffered a loss because of this. Liability for misfeasance is, it is the improper performance of a lawful act or breach of trust or duty imposed by law. He is given some, for example, he is given some duty. He has to do that duty. If he wrongfully does that or completes that work, then that will be called as a liability for misfeasance. If he is not fully does his duty, though he is doing his duty, but it is not done proper, in a proper manner, properly, then such a liability will be called as liability for misfeasance. Clear? So here in civil liability he will be just liable to pay a fine. It can be any amount of fine which is considered under a different section. So I'm not going to give the information of that now. Next we'll go to criminal liability of an auditor. Criminal liability means liability for a crime. Knowingly if he commits some mistake, then it will come under this category. That is misrepresentation of facts, falsification of facts, making a false statement, destruction of any voucher or documents, or doing any wrongful act with the intention of cheating another party or a company. It will be considered under this. And the penalty for criminal liability of an auditor may be fine or imprisonment or both. Sometimes both cases or both things will be applied to the auditor depending upon the extent to the cheating what he has done to the company's client. Okay, first we'll go through the first one. Criminal liability of an auditor under Companies Act of 1956. You have so many points. I'll go one by one. For misstatement in prospectus, if auditor knowingly included, or he knows that in prospectus which is issued by the company to the public for getting the funds from the public contains mistrue statement, that is misstatements, false statements, in such a case he will be liable for imprisonment of 2 years or with a fine which may extend up to 5,000, or in some cases both. Second, for fraudulently inducing persons to invest money. If auditor uses some or induces or forcefully make a person to invest in the company or invest their money in the company, knowing that they are making, they are cheating, or they are deceiving those people who are going to invest their money, in such a case it is considered as a crime, and again he will be punished with the imprisonment for a term up to 5 years, or again 10,000 fine may be charged, or both. For non-compliance with Section 227 and 229 of the Companies Act. In some cases, according to the requirement of Companies Act under Section 227 and 229, they have given some condition for reporting and for signing some authentication, some certificate by an auditor. If he is not going to compile with these regulations of a Company Act, then he can be punished with the amount up to 1000. Next, for failure to assist investigation, according to or as per section 240, if the auditor fails to help the investigators who has been appointed by the central government, then he will be punished with imprisonment up to 6 months or a fine up to 10,000 or both. Next, for failure to assist prosecution of guilty officers, as per section 242, if the auditor fails to assist or help the prosecution of guilty officers, the people who have the officers who have cheated the company, if he doesn't help to the central government in their prosecution, then again he will be punished with imprisonment for 6 months or with a fine up to 500 or both. For failure to return property, books or papers, when the company is wound up, the court may direct the auditor to appear before the court and to return to the court the properties, books, or papers of a company. If the auditor fails to give back or return properties, books, or papers related to his client company, he can be arrested. For falsification of books, as per section 539, if documents or the important files related to the company is destroyed, mutilated,